fall off. Ma'am, I just bought this car. I didn't have no transportation to make the last class, and I was going to complete the last class. I even much have the money right now to pay off my whole probation. I just didn't. It's it's the people that was around me, man. My family did not want to see me make it.
Right from the jump, you can feel the tension. He's blaming the people around him, the universe, the weather, everyone except himself. Classic courtroom energy. But watch closely. This attitude ends up shaping the entire hearing.
Welcome back to Time Serve, the channel of scandals, so you don't have to. The word is no. And when you're facing close to a decade in the TDC, I guess that two-letter word is one of the last ones you want to hear comes out of Judge Boyd's mouth. But today, this defendant has been in and out of the 187 for years, and finally, his luck has ran out. But he will not accept it, and he has a problem calling judge by judge. He had a principal that he called Mr. Boyd, therefore he calls her Mrs. Boyd. It gets very confusing, but entertaining. Tell us how you feel about this defendant who won't shut up by commenting down below.
Court is calling 2020-23 CR 10366 State versus Claudel Dwayne Corney. Can I have parties announced for the record for the state?
Opinion for the state of Texas.
Good morning. For the defense?
Christopher Ramos for the defense.
And are you Mr. Carney?
Yes, ma'am, this is me.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Ms. Boyd.
Are you the same Claudel Dwayne?
Yes, ma'am.
All right. Are you the same Claudel Dwayne Carney who was placed on deferred adjudication in 2023 CR 10366 for the offense of aggravated robbery on February 13, 2024 for a period of 10 years? Is that you?
Yes, ma'am. That's correct.
All right. State.
Yes, Your Honor, violation of condition number 41. On or about the 8th day of September, violation of condition number 41. On or about the 8th day of September 2025 in Bexar County, Texas, the defendant, Claudel Dwayne Carney, did then and there fail to register for, attend a moral recognition therapy program with an approved agency in violation of condition number 41.
All right. If we could go off the record for a moment, I don't have a violation of condition number 41. Is that in a supplemental?
No, Your Honor, it's the original ETR.
It is they and their word that seals a deal. True. When a defendant pleads true to a violation, the judge basically gains full power to impose the original sentence. That one word can mean freedom or years behind bars.
All right. To the violation, how do you plead, true or not true?
True, ma'am.
State will waive the other two violations, Your Honor.
Any objections to the state's waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, find you guilty, and sentence you up to life in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, Your Honor.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There's not, Your Honor. Both state and defense are going to make the recommendations to it, Your Honor.
All right, state, what are you requesting?
Before I make my argument, Your Honor, I ask the court to take judicial notice of the court's file.
All right. What specifically do you want the court? I know you say the court's file, but is there something specifically?
The facts of the underlying offense and his history on probation.
All right. You may proceed.
Thank you, Your Honor. We're here for the defendant's motion on this aggravated robbery charge that he is on probation for, and Your Honor is aware of the facts of this case, being that he initially stole that victim's phone, ran away with it. The victim was lucky enough to later find him at a gas station close by, and when the victim asked for his phone back, the defendant pulls a knife on him and says, "Come and take it. Come and get it." With a deadly weapon, he threatened someone's life, therefore being placed on probation, for 10 years.
This is where the stakes skyrocket. Pulling a knife over a stolen phone, that instantly bumps the entire case into deadly weapon territory, which courts take extremely seriously. You can almost feel the judge mentally tightening the screws.
We're here on the second MTR this defendant has had within the last 4 months for same violations as it was just 4 months ago in June, Your Honor, where the defendant had a new number one that we unfortunately had to waive. That victim was his sister. He assaulted her. She did not want to come in to support that day.
Well,
I would strongly object.
all right, that objection will be sustained. If it was waived,
Okay.
then it will be sustained.
We reluctantly had to waive number one today. We were ready to proceed on the contested MTR yesterday. Victim here, sister here, to testify about what he did to her. They decided not to show up today. Therefore, we had to proceed on the technical violation of condition number 41.
Well, I mean, if you would like, my understanding that there would be no objections. If they would like to zoom in, I was going to say it was working.
Formally, Judge, I don't remember, for the benefit of the record and on behalf of my client, I would have to object on their appearance on Zoom. I would ask them to appear in person.
Okay. All right, you may continue.
Only because of the defendant not coming yesterday, we were unable to proceed with trying to prove the assault that he committed against his sister on September the 4th, 2025.
Okay.
As such, because of the underlying offense, because of his history, because he had the opportunity that Your Honor gave him back in June to go to Louisiana like he requested, but instead chooses to commit new crimes, they feel that he is not an appropriate candidate for probation. He should be revoked. He should be adjudicated guilty. There should be an affirmative finding of deadly weapon. State is seeking that Your Honor sentence to the 10 years TDC.
All right, defense, you may proceed.
Specifically to speak to him not registering or attending the moral recognition treatment course. My understanding is that he failed to, at least the date alleged, is a date in September of 2025. As he describes to me, he was released from jail.
Here's a crucial moment. The defense leans hard into mental health struggles, transportation barriers, and a chaotic home environment. These arguments can absolutely sway a judge, yet they're backed by consistent effort. The big question, did the defendant show enough effort?
In July of 2025. And he does admit to me that he did not register for the class. And part of that where he was struggling was a combination of him dealing with, as the court may be aware of, some of his mental health struggles that he's dealing with. He reports to me that he is schizoaffective, dealing with bipolar. I believe probation has some information about that. And he was also struggling with transportation. At this moment in time, in September, I think he was just struggling to function as an individual. He was just struggling to function. But I would ask the court to be mindful that while on probation, as far as I can tell, he's completed some of the outpatient requirements. He's completed anger management. There were a series of events where he tested for substances and he came back a series of times negative. He's been to DDRF, and when I ask him about his experiences there, he's able to recite their philosophy, the things that he learned. He's describing that he learned strategies on avoiding conflict, on what his triggers are. And other than this allegation of assault and a minor relapse with a substance, I think he's doing the best that he can. I think he was living in a household that was pretty volatile. And I think he's living with other individuals that struggle with them. They struggle in terms of how to deal with his mental health issues, and it's a bad recipe. Mm-hmm. I have a sense that he's doing his best. He describes to me he wants to fight the new number one as it exists on its own because it's a new case. So we are respectfully asking the court to continue him on probation with some sort of jail sanction, and to be mindful that he has given his mental health. He's doing his best to accommodate. That's the wrong word. To fulfill the agreement he's made for probation. So for that, Judge, we're asking for you to continue him.
All right, probation.
We have his probation officer here as well. We're going to feel like we hear from him.
No, I mean, what is the recommendation?
Oh, Judge, so what's listed on the court summary is DDRF followed by 6 months sober living at approved location, and ISP supervision upon DDRF, bi-weekly UAs for 60 days post DDRF. He did complete DDRF 121 days. He completed an outpatient program. He completed an anger management program. He has not completed the moral recognition therapy, the referral for Center for Healthcare Services. His last UA in August of 2025 was positive for amphetamines. And his last office visit with his officer was in August of 2025.
All right.
And I'm thinking that's because maybe that's after that his respiratory signal.
Okay. So here's the thing, Mr. Carney.
And that's the turning point. Once a judge says you're not appropriate for probation, the room gets cold. That's judge language for, I gave you a chance, you didn't use it, and now we're done. This is usually where outcomes shift from rehabilitation to punishment.
Yes, ma'am.
I don't think you're appropriate for probation. I granted your application over the objection of the state,
Yes, ma'am.
and I can only do so much. What the court is going to do is the court is going to find violation of condition number 41 as previously stated. The court is going to sentence you to 6 years in the prison, give you credit for any time served. The court will recommend the therapeutic community. There's an affirmative finding of deadly weapon. The court will give you credit for any time served for successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am. I don't want to say that you're moving too fast, Miss Boyd.
Judge.
No.
Miss.
Well, that's fine. You can call me Miss Boyd.
My principal in Shelman Middle name was Mr. Boyd.
Okay.
Ma'am, I get it. I just came home November 1st and consistently back in your courtroom, and I am ashamed. Also, ma'am, the new class that you signed me up for, told me to go to, I didn't have no transportation. I didn't have no kind of ride. I'm getting kicked out of this house that my brother had owned, caught a heart attack in, and it had multiple individuals in there. I haven't even spoke my mind about what's going on in this house, from guns, drugs activity, and Center for Healthcare helped me, got my food stamps. Just one of the two same sisters are stealing my food stamps. Those are triggers that I learned. So I removed myself from that household consistently. But I always went back because you know why? That's where I probate to. That was my original.
No, so here's the thing. I tell everyone who's on probation in this court, if there's an issue, all you have to do is let probation know about it.
I did, Miss Boyd. And also, I was trying to tell you, like, recently, I just cleared a $25,000 lawsuit. Only thing I did for myself, ma'am, was buy a brand new car. It was $12,000. It's in New Orleans. My niece was driving it to me the day that I got locked up, ma'am. Consistently, if the system, I'm not going to say the system failed me. I love Mr. Alcatar, my probation officer. I wish he could speak up on my behalf. Ma'am, no. And I just moved back to San Antonio because I just recently found out in 2023, I have a 12-year-old baby that I did not know I was able.
So here's my question. Why didn't you contact probation and say all of this was going on in your life?
I tried, Miss Boyd. I really did. Because I was in jail. I didn't know not one, but two of my siblings passed away. One of them overdosed from drugs. And
so here's the thing, what I want you to internalize.
Yes, ma'am.
This is what I want you to internalize. I took into consideration your mental health issues when I granted your application for deferred. And I granted that application for deferred over the objections of the state. So what that means is you need to be on what's called your P's and Q's and make sure that you're doing everything that you're supposed to be doing. and
Yes.
you're not. So I just don't think you're appropriate for probation. So I'm not going to continue you.
Yes, ma'am. All right. But Mr. Alcatar, I can have a peaceful word with Mr. Alcatar before I leave
For
the
what
courtroom,
purpose?
because he could tell you some of the things that I was going through before I got locked up, ma'am. I was explaining this, the stuff that you said that I wasn't explaining to probation.
Mhm.
I was explaining to Mr. Alcatar. I knew it was going to be. I didn't know how it was going to happen, but I knew it was going to happen. I was going to fall off. Ma'am, I just bought this car. I didn't have no transportation to make the last class, and I was going to complete the last class. I even much have the money right now to pay off my whole probation. I just didn't.
This part hits hard. When a defendant keeps talking after sentencing, it usually comes from panic, not strategy. But in court, over-explaining can backfire fast. Judges see it as deflection, not accountability. The emotional weight is real, but so are the consequences. So,
It's the people that was around me, man. My family did not want to see me make it. I have all my probation fines and fees, the whole 7,000.
Oh, here's the thing. Your attorney can address with you whether or not you should be spending money to pay that because you're no longer on probation. That would be money that
So I to do 6 years, Ms. Boyd.
you'll get credit for any time that has
You
been
could tell
served.
me how much time served that do I
To
have?
the clerk, can you look up how much time?
And what about the credit for time served the last time when I was?
You'll get credit for any time that you've been in custody on this case, even prior to being placed on probation. Did you review the trial court certification of defendants' rights to appeal? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion.
Yeah.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, Ms. Boyd.
All right, thank you. You're welcome.
That's it, please.